Hey everyone, I'm Rafe Schaefer, and I'm joined today by Andrew Price. We're here with another edition of the Texas Business Court Insider. Today we're going to be talking through the Oklahoma Supreme Court's decision in White versus Stitt, where the Oklahoma Supreme Court declared Oklahoma's new business court unconstitutional. Andrew, can you give us some background on Oklahoma's business court?
Well, for sure. So this was a priority of Governor Stitt in Oklahoma and the Oklahoma legislature. And so in May of this year, May 2025, there was Oklahoma Senate Bill 632, which created a business court in the larger Oklahoma counties, the ones with over 500,000 people living in them. So basically Oklahoma City as well as Tulsa. And the courts were set up, and this will be important as we dig into this, the courts were set up as divisions of the existing district courts in those counties. And the law authorized salaries for these new business court judges and granted the governor the right to appoint them pursuant to Oklahoma Senate confirmation. Suit was almost immediately filed after passage of the bill in the Oklahoma Supreme Court directly. And in June of, that happened in June of 2025. And they asked the court to declare that this new bill and the creation of this business court was unconstitutional under the Oklahoma Constitution. And very quickly, the Oklahoma Supreme Court had oral argument kind of in mid-July. And just about 2 weeks ago, the Oklahoma Supreme Court issued an opinion declaring Senate Bill 632 unconstitutional. Rafe, why don't you walk us through a little bit more of the details of that opinion and what the defects were?
Sure. So the key question in that case was whether the method of appointment of judges was unconstitutional under Oklahoma law. The petitioners argued that Senate Bill 632 violated the Oklahoma Constitution by allowing the governor to directly appoint the business court judges instead of requiring those judges be elected. The governor contended that the business court was a different species of court and the appointment process didn't violate the Constitution. Now, you mentioned, Andrew, that the fact that the business court was a division of the existing district court was important. And that's because the Oklahoma Constitution specifically created a subset or the types of courts that could exist: the Supreme Court, the Court of Criminal Appeals, state industrial court, bank court, tax court, and then the district court. But the Constitution didn't allow for the creation of the business court or the creation of additional specialty courts. So Senate Bill 632, pursuant to that constitutional setup, created the business court as a division of the district courts. And the Constitution also requires that district court judges be elected in Oklahoma. For that reason, the appointment process of business court judges who were a division of district court judges was unconstitutional and the law was struck down. Andrew, for those who have been following the Texas business court, obviously there's an appointment procedure for judges in Texas. Do you think we'll see a similar challenge to the Texas business court?
Well, we haven't yet, right? The court's been in place for a year, and there has not been a constitutional challenge to the business court. As watchers know, there was a constitutional challenge to the creation of the 15th Court of Appeals. That was rejected. But heretofore, we don't have such a challenge at the business court level. And I don't know whether the fact that this opinion occurred in Oklahoma is going to cause a change. Maybe it will. But I think there's some key differences between the Texas legislation that created our business court and what happened in Oklahoma. And it really goes to kind of the sophistication and care that the Texas legislature took in crafting our business court. As you touched on, key difference, the Texas Constitution specifically allows for the legislature to create specialty courts. And while Texas judges generally have to be elected, The Constitution says they only have to be when they're going to serve 4-year terms or longer. And so we've talked at length about the fact that these business court judges are on a 2-year appointment cycle with the governor, and that is in part designed to comply with that provision of the Texas Constitution regarding election of judges. So there's some key distinctions between the Texas Business Court and the Oklahoma Business Court that I think, at least heretofore, have prevented such a challenge.
It'll be interesting to see how these issues develop, and to your point, whether the Oklahoma challenge and result will, encourage someone to bring a constitutional challenge, or if a unhappy litigant at the end of a case may raise a constitutional challenge. And then, of course, there would be all questions of waiver and consent. But as you and I have discussed, Andrew, it really feels like, looking at the development of these specialty courts around the country, we're on the cusp of creation of different types of specialty courts that goes back hundreds of years, when the initial divide in courts of law and courts of equity were created. Obviously, that distinction, the difference between courts of equity and courts of law, the Court of Chancery in Delaware is a court of equity. That has led to some of its specific abilities to have these, chancellors and vice chancellors ruling on equitable issues relating to these, corporate formation, which other states are trying to implement or imitate through these various business courts. And the Court of Chancery still sits only in equity today, which limits its jurisdiction. Obviously, these various different statutes being passed have different jurisdictional limits. Andrew, I know you and I have, had some discussion about these various jurisdictional issues and how we think that may play out into the future.
Yeah, I think it's been really interesting, obviously on the front lines here in Texas, but as well these other courts around the country. We're really, and we saw this in Oklahoma, we're really grappling with kind of some old school separation of powers type issues that in a lot of instances we haven't had to deal with for a long, long time because we have not been creating new courts. And so in Oklahoma, in the case we're discussing, you're kind of seeing the Oklahoma Supreme Court, the judicial branch, flexing its muscle and saying, hey, Governor, we understand the executive and the legislature want this business court, spent a lot of time trying to create this business court, but at the end of the day, it doesn't work the way you tried to do it under the Oklahoma Constitution. And so what'll be interesting to see now, obviously, because it's a policy that the executive and the legislature in Oklahoma support, having a business court, I guess we're going to need to see, are they going to go try to amend the Constitution? Are they going to go back to the legislature and try to rewrite the bill to cure the infirmities that the Oklahoma Supreme Court pointed out? We're just going to have to keep an eye on it.
Yeah, it'll be interesting to watch continued developments in Oklahoma and other states, and certainly we'll be keeping an even closer eye, here home in Texas. And for those watching, the Texas Business Court Insider will continue to keep you updated as the court continues to evolve and developments continue to occur in Texas and around the country. Remember to hit like and subscribe so you get notified when our next video drops. Thanks.